Let's see, jurisdiction. California. What year was the California Constitution enacted? We just say the word published. Enacted means a legislator did it. Okay. When a constitution is created, there's no legislation involved. It is the people creating a government. So in 1851, actually in California, I believe it was 1849. Let's see here. First, let's Google it. I got my laptop. These boys in trouble now, boy. First California Constitution. November 13th, 1849. See, this is what's significant. When we talk about constitutions, when we talk about jurisdiction, we have to understand that, especially if you're not one of the original 13 states, that California Constitution, for example, okay, well, that Constitution was created before they joined the Union, meaning before they joined the United States of America. California didn't join the Union. Let's Google that. California joined the Union. Oh, I didn't type in California. California joined the Union on September 9th, 1850. Okay, well, the people created that Constitution before there was such thing as a United States, before they joined the Union. That first Constitution of California has never been repealed. That Constitution is still active today for the people of California who created it. A legislator cannot get rid of a constitution. They tell you they can do it. They can't do it. They would have done it. They would have done it by now if they could have did it, but they can't. Right? So when does jurisdiction for California start? 1849, when they created the government called the state of California, right? So California government was created in 1849, and nobody from the United States was there when that was created, meaning the feds. So no Fed was there when the California Constitution was created. See, we got to understand how significant this is. So when you go to study California law, you got to start with that 1849 Constitution and I've proven it a lot. I don't live in California. I'm not from California, but everything in that Constitution has never been repealed, never been done away with as far as it relates to that 1849 Constitution. You can find Supreme Court cases today about when they say constitutional, they're not talking about whatever the latest California Constitution is. That's not the California Constitution, right? So they said, what they say, November 13th, 1849, in Colton Hall, Monterey. That's when jurisdiction started for California. And that's where their jurisdiction starts. That's where their sovereignty is explained and defined. This is the same for all the states. So Texas would be the same. This is the same for all the states, right? So when we talk about constitutions, we don't focus on the federal constitution because that federal constitution is not talking to us. It's talking to a government. So if you were born in California and you are by nationality a Californian, okay, well, you got a constitution that started in 1849. And you need to read it, you need to study it, you need to know it. That is your jurisdiction. Before we even get in jurisdiction, that's the jurisdiction. They say, I can't prove all of this, but you'll have to find which version of your state constitution. They'll say whichever one has the geographical boundaries of your constitution, of your state, that's the one you need to start with, quote unquote. Technically, you use all those constitutions. There's no such thing as two constitutions. Since they never got rid of it, they can't create another one. There's a constitution talking to the government, from the government, and then there's a constitution by the people talking to the government, right? So you have one constitution. And those Bill of Rights, all constitutions are talking to governments. But in understanding the powers of government, you will study all of them. Just like you won't study the United States Constitution. I'm going to do it one day, Lord willing. I'm going to teach you, you can fight everything from your state constitution. Everything from your state constitution. That's the thing they don't want you. Why? Because the feds did not create your state constitution. They can't even take it. They can't even take what they call it judicial notice of it. Why? Because they didn't create it. It's not pertaining to them. It's pertaining to the people of California talking to the government. That's what a constitution does. So you don't have a United States Constitution. You have if you were born in California, you got a California Constitution. If you were born in Arkansas, then you have an Arkansas Constitution. Someone said there is a direct quote stating the federal Constitution is the floor for your rights in the state. That can't be. Rights don't come from governments. There's no floor. The Constitution is not the floor for my rights. My rights come from God. My rights come from Jesus. That's what the Declaration of Independence say. He say, oh, I got my laptop. I got it right here. I got it right here. Y'all don't know. I haven't had my laptop in 4 months. So I'm very excited. Thomas said, we hold these truths to be self-evident. That's a quote from the law of nature. You want to learn what's the law of nature? It's self-evident. You don't need no pieces of paper for it. They didn't need a Declaration of Independence or a Constitution. They said we hold these truths to be self-evident, that all men are created equal, and they are endowed by their creator with certain unalienable rights. And among these are not constitutions, Bill of Rights, codes, regulations, ordinances, regulations, rules, the police department. No, they said among these rights are life, liberty, and the pursuit of happiness. And that to secure these rights, so they said rights existed before there was such thing as a government. They said, and to secure these rights, the rights that existed before there was such thing as government, they said governments have been instituted among men. And these governments derive their powers from the consent of the governed. Who is the governed? The people. We gave them permission, right? And Thomas says, okay, so to secure rights is the purpose of government. See, I don't have time. We're not going to talk about this today. We're going to talk about jurisdiction. And the Declaration of Independence is what they call a legal document. You go look up the word declaration in a law dictionary. They say this is how you form a court case. This is how a court case gets started. They say this is the backdrop. We're giving an accusation against the government of Great Britain with this, right? That dude's a monarch. He's a sovereign. And they say, yeah. But we hold these truths to be self-evident, that no matter what you call yourself, no matter what you think you are, to whom you think you are, you may own the land, but in order to be called government, in order to be called king, you may own the land, right and good, but in order to be in charge of people, you get that power from the people. You derive that power from people. God did not give you that power. We gave it to you through consent. We already had these rights with or without government, with or without a king, with or without a monarchy. You know how crazy that is? They said that to the King of England, y'all. These boys had what we call balls. Thomas Jefferson said, that to secure these rights, governments are instituted among men, and these governments derive their power. See, they said the rights come from God, but the powers of government come from people. They said from the consent of the governed. And Thomas says, whenever any form of government, a monarchy, a republic, a democracy, whatever you want to call it, whenever any form of government becomes destructive of these ends, what ends? You are no longer securing people's life, liberty, and their pursuit of happiness. Okay, well, it becomes the right of the people to alter or to abolish that form of government and to institute a new one. And they're going to lay its foundations on the principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. They said that's the purpose of government. That's why we do it, right? So the Constitution can't be the floor for rights, because that's not where rights come from. Right? So we don't study the Constitution to learn where our rights from. Rights come from the Creator. That's where rights come from. They don't even get that word from nowhere else. It ain't come from a government. Can't give rights. Can't take them away either. And I'm gonna prove this real quick. Oregon. We like Oregon. We just got back from Oregon. They said this is Oregon sovereignty. They said this is the Supreme Court of Oregon in 2025. I read this thing almost every day now, right? Whenever I'm on here. They said the powers of the government are limited. Somebody said, what? He said, Constitution. There's a direct quote stating the federal Constitution is the floor for your rights. No, that can't be the floor for the rights. They didn't come from the Constitution. They said they got their rights from the common law of England. You know what the unalienable and inalienable are interchangeable. That's the exact same word. That it's literally, I'm on the National Archives Declaration of Independence, and you know what it says? Inalienable. And that word is in a law dictionary. Watch this. I have 30 law dictionaries here. Let's go look it up. Inalienable. See, he want to talk about my comprehension, knowing that the words in 1776 are not spelled in the same way they're spelled in 2026. But you want to talk to me about comprehension. No, I comprehend it just well. Thank you very much. Inalienable is a real word. There we go. Inalienable. That's a real word. Anyways, Oregon said, the powers of the government are limited, and those powers must be bestowed upon it by Oregonians. Who are the Oregonians? Those are the people on whom sovereignty has been vested in from their creator. They said the Oregon Constitution does not confer rights upon Oregonians. They said there are rights possessed by every Oregonian. Possessed. That's a spiritual term. You are possessed with it. The same way you breathe life. They said these rights limit the power and behavior of the government. They said this is based on Article 1, Section 33 of the Oregon Constitution. So when somebody says the federal Constitution is the floor for your rights, no, it can't be the floor. The floor is the ground that God created. A piece of paper cannot give somebody rights. A piece of paper can't take them away. Right? So, where do rights come from? If you don't get that, you'll never get anything. Thomas Jefferson said it. We hold these truths to be self-evident, that all men are created equal and that they are endowed by their creator. What did Oregon just say? The powers of the government are limited and must be bestowed upon it by the Oregonian. Who created the Oregon government? They said there are rights possessed by every Oregonian. They said the Oregon Constitution does not confer rights. It can't give rights. It don't have no rights to give. All it has is restrictions placed on government. There are no rights in there. You won't find them there. You want rights? You're going to have to go to the laws of God. You have to go to the laws of nature. Jurisdiction. We're going to talk about jurisdiction. Jurisdiction. Everybody say jurisdiction. The word of the day is jurisdiction. I keep getting these books. Y'all don't know me, but I buy books. Sometimes I buy a book. It's very bad. It ain't got nothing in it. Sometimes I buy a book. It's got everything in it. It's got amazing information. And I try to compile it and store it and give it, you know. And then sometimes I get a book and it's got bad information in it. It has presumptions, and presumption is a curse word to us. We don't like presumptions. Presumptions mean we believe blindly what somebody says and we cannot prove them wrong. We don't like presumptions. The whole government operates on presumptions. Every police officer acts on presumptions. Your attorney, the magistrate, the judge, everybody acts on presumptions. They want you to believe things are true without them being proven. And we cannot live life like that. We have to scrutinize everything. In the age where mass deception is a thing, where people lie straight to your face, we have to question everything. We have to question everybody. It's actually healthy to do that. If you don't live a life where you don't question anything, okay, well then you're subjective, or you're prone to be susceptible. I think that's the word. To deception, right? You're prone to be lied to, right? So the word of the day is jurisdiction, because I feel nobody gets jurisdiction right. Let me see if I can get a definition pulled up. What states are we from? Tell me what states. Tell me what states are we from. I had a whole thing of like 7 dictionaries pulled up, and now they are not. Let's do susceptible. That's the word. Look at that. Massachusetts is in the house. We're going to look up 2 dictionaries. Let's see here. We're going to look up Ohio, Massachusetts. Let's go. All right, let's see if we can find the word jurisdiction. I know it, but we'll make sure we read it accurately. What is jurisdiction? Jurisdiction is the power of the courts to hear and decide a case. Jurisdiction is the power of the courts to hear and decide a case. We got to go all the way down to the J's. Jurisdiction is the power of the courts to hear and decide a case. Somebody just type power of the courts. That's what jurisdiction is. Is the power of the courts to hear and decide a case. Jurisdiction. J-U-S-L-M-N-O-P-Q-R-S. Jury. Jurisdiction. There we go. What is jurisdiction? Jurisdiction is the power and authority constitutionally conferred upon a court or a judge to pronounce the sentence of the law. It is the jurisdiction. Jurisdiction is a power constitutionally conferred upon a judge or a magistrate to take cognizance and of determined causes according to law and to carry his sentence into execution. Jurisdiction is the power of the courts to hear and decide a case. Now, what is the operative word? Case. Case is the operative word. Let's go to the Constitution. We don't read the Constitution for us. We read it to study law as a general subject, right? So there are three branches of government. You have the legislative branch, you have the executive branch, and you have the judicial branch, right? All right, well, jurisdiction is the power of the courts to hear and decide a case. Well, what type of cases can a court hear in America? All right, that is not Article 3. Article 3, right? They tell you. Let's read it. This is a federal constitution. This is not for you. This is for them. You need to go to your state's constitution and read the judiciary there. Article 3, they said the judicial power of the United States. What's the United States? The District of Columbia. It's not Arkansas. It's not California. It's not Georgia. It's not California. It's not New York. It's not Idaho. It's not Minnesota. It's not North Dakota. It's not Oregon and Washington. There's no such thing as the United States and Arkansas. There is Arkansas. There is Arizona. There is Alabama. All right. So Article 3, Section 1 gives us a backdrop. They say the judicial power of the United States. So the judicial power of the federal courts shall be vested in one Supreme Court and in such inferior courts as Congress, that's somebody else, that's not the judiciary, shall from time to time ordain and establish. They said the judges of both the Supreme and inferior courts. Now this is sexy. I like this. They said they're judges of the courts. They're not judges of the law. Judges of the courts, not judges of the law. Who are the judges of the law? Watch this. Well, I'm going ahead, but I'll come back. They said the trial of all crimes shall be by jury. Who are the judges of the law? Who are the judges of the courts? Two different people. You got a magistrate. He's the judge of the courts. He's the judge of the building. He's the judge over the ceremony. They call them magistrates. They call them ministers. But the judges of the law, you'll have to go to your state constitutions to know who the judges of the law are. Right? So they said there are judges of the courts. You get down to the end of Section 2 and they say, well, the trial of all crimes shall be by jury. Remember, this is the federal constitution. They're talking about federal things. We're using this as an example to understand jurisdiction, right? All right, so they said there shall be vested in one Supreme Court. To them, they have a Supreme Court. To the federal government, they have a Supreme Court. In Maryland, they also have a Supreme Court that's not ran by a magistrate. Oh, this is fun. I got my laptop again, boys. We're having fun. So a Supreme Court in the federal courts, in the federal jurisdiction in the federal government is not the Supreme Court in your state. Why? You don't get into a court federally unless there's a commercial contract. So we're talking about two different types of jurisdiction here. We're talking about federal jurisdiction. We're talking about state jurisdiction, right? So a Supreme Court, so they say They said the power of the United States shall be vested in one Supreme Court and in such inferior courts. So they say there's two type of courts. Federally, right? But technically all of those are inferior courts. Why? Because a magistrate is not a judge of the law. He doesn't have the supreme authority of the law federally or state-wise. Why? Because if I get a jury and the jury says guilty or not guilty, all the years of law school, all the years of being a bar member and being in the courts and being an officer and all that, it means nothing to a jury. You can't appeal the verdict of a jury, good or bad. You can't appeal a verdict of the jury. Why? Because they decide the law. Who is it? I forgot I got my laptop, boys. I got it. I can prove so much stuff right now. Let's see here. Let's go to my notes. Let's go to my notes. Let's get bright mode, and then we're going to search Maryland. Maryland. We like Maryland. The Oregon Constitution said that the jury determines the law and the facts. The Indiana Constitution said the jury determines the law and the facts. The New York Constitution said the jury determines the law and the facts. The Maryland Constitution said the jury are the judges of the law as well as of the facts. Who determines the law? Does a magistrate determine the law? No. You'll never find legally or lawfully or constitutionally a magistrate in America determining the law. They have what they call opinions and findings. They don't determine the law in America. See, on the lowest level, if you get a jury, you get an injured party, you get a grand jury, and you get a trial by jury. Okay, well, that's the Supreme Court. You can't appeal any of that. You can't appeal that up to the Supreme Court. The act is final. Good or bad, the act is final. Injured party, grand jury, trial by jury, that's the Supreme Court. See, they got a Supreme Court. That's not the Supreme Court. Does that make sense? So, jurisdiction is the power of the courts to hear and decide a case. What type of cases exist in America? We're about to go over it. All right, so let me read this. This is a federal constitution as an example. The judicial power of the United States of the federal government shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. So you see the same pattern in your state constitution, right? So what you're going to learn from that is the legislator, whatever your state calls the legislator, the assembly or whatever, the general assembly or whatever, they establish inferior courts. And those courts get power through statutes. And you get connected to those statutes by your consent to those statutes. They don't have power in and of themselves. They have to know who you are in order to bring you in there. But that I'm going to get to that in a second. All right. So they said judicial power shall be vested in one Supreme Court and in such inferior court. So you see all this for your state, right? Your state has a Supreme Court and then they have inferior courts. But outside of a trial by jury, they're all inferior courts. The judges of both the Supreme and inferior courts, they're not judges of the law. The Constitution never says that. They're judges of the courts. Shall hold their offices in good behaviors, yada, 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 compensation, yada, 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 right? Then they say judicial power, this is section 2 of Article 3 of the Federal Constitution, judicial power shall extend to all cases. And then they tell you the cases. They say in law, what's the law of your state? See, that's a whole subject in and of itself. Judicial power. They didn't say the judges of the courts would have judicial power in all cases in law. Why? Because they don't determine the law. They said judicial power. That means when you get on the jury, that when they call it law, that's your role. That's your power right there. And then they got this thing called equity. Okay, that's for the guy in the black robe. But when they talk about law, oh, that's you. That's you put on your robe. And never mind. All right. So judicial power shall extend to all cases. What kind of cases? They got this thing called law. What's the law? What states are we from? Somebody said we from Ohio, Massachusetts, Arizona, California. Okay, well, what's the law of California? What's the law of Arizona? What's the law of Ohio? What's the law of Massachusetts? Right? If the answer is the common law of England. Right? So they got this thing, it shall extend to Kentucky. What's the law of Kentucky? The common law of England is the law. The Constitution is not the law. Constitution just tells the government what it can and can't do. So they said judicial power shall extend to law. It shall extend to equity. It shall extend to issues arising under the Constitution, and then laws under the United States. They say laws of the United States and the Constitution are two different things. They said the law, the Constitution, and the laws of the United States are three different things. And equity. Equity is not law at all. So they said these are type of cases that you can hear. And then there's a specific subject of law within those different topics. Right? So when you talk about law in America, okay, it's not the same law that's in Brazil. That's not the same law that's in Colombia. That's not the same law that's in an African country. Right? So here we got this thing called the common law of England. That is the law. Then they got this thing called equity. Those are principles and different things on how they apply certain things. Okay, well, that's a whole different subject. Then they got things arising under the Constitution. Then they got things arising under the laws of the United States. Then they got this thing called treaties made, or which shall be made under their authority. Then they say they got this thing called cases affecting ambassadors and public ministers and consuls. And then they got this thing called cases of admiralty and to maritime jurisdiction. Okay, well, those are law, equity, Constitution, United States, treaties, ambassadors, public ministers, consuls, admiralty, maritime jurisdiction, things. And then they keep going. They say things on which the United States shall be a party, controversies between states, citizens of those states, between different states, between states and lands and grants under those lands in different states, states and the citizens, foreign states, citizens and subjects. They said, what is this? Federally, they're talking about international things. Then they say they got cases. We already said this earlier. Cases affecting ambassadors, public ministers, consuls. So right now, right, they got the World Cup. Okay, well, any dignitary from any other nation that's in one of the states right now. Okay, well, the feds got to deal with that. That's a federal court power right there, right? Okay. And then in those where the state shall be a party, the Supreme Court shall have original jurisdiction. They said in all other cases, the Supreme Court shall have appellate jurisdiction. Okay. Well, what's the appellate jurisdiction? You have to appeal all the way up to the Supreme Court. But I don't have time. I'm not going to go into it today. You don't get to go up to the Supreme Court unless there is a commercial issue. So, yada, yada, yada. The Supreme Court shall have appellate jurisdiction as to both law and fact, with such exceptions under the regulations as the Congress shall make. And then they said, so let me go over it one more time before I finish up. They said they got judicial power of the federal courts. We're talking about federal things as an example. Law, equity, constitutional, federal, United States, treaties that shall be made, ambassadors, public ministers, consuls, and then I'm going to treat that as one thing. So then you got cases of admiralty and maritime jurisdiction. And then they got this thing called criminal law, because they said the trial of all crimes except in cases of impeachment. What's that? That's a federal issue. That's not a crime. That's a commercial issue. Shall be by jury. And such trials shall be held in the state where said crimes shall have been committed. But when not committed in any state, the trial shall be at such places or places as Congress may by law have directed. Now, again, they're talking about federal things inside of federal areas, but that's another topic, right? So those are cases. Those are cases in America where, depending on which of those issues, you will end up in court over, or can end up in court over. Some of those you'll never end up in court over, right? Some of those you're not supposed to be in court over, right? So remember, this is federally. We're just using federal as an example. You need to go read your state's constitution and understand the powers that you gave to the state government, right? So jurisdiction is the power of the courts to hear and decide a case. That's a pretty good explanation. You got different types of cases. Not all cases are blanket. The courts aren't magical. They don't have jurisdiction over everything. And for 90% of those issues, you do not get in there unless you have done something to give the court its power. Does that make sense? So jurisdiction is the power of the courts to hear a case. Okay, how a case gets created is a whole different topic, right? The federal Constitution is significant because in Article 1, they got this thing called commerce. Commerce is in the Constitution 2 times. Article 1, Section 8 says that Congress, we're talking about federal things now. Federal. Article 1, Section 8 says that Congress shall have the power to regulate commerce. Did they create commerce? They can regulate it. They regulate it with foreign nations, among the several states, and with Indian tribes. See that word, every word in the Constitution or every major phrase in the Constitution has a definition. Every word in the Constitution, state or federal, has an etymology. Let me see, I got a quote on that. Is this guy named Robert Trench. Oh. Excuse me. I think his name is Robert Trench. Let's search Trench. Yep, Richard Trench. Richard Trench was an Anglican archbishop, poet, and scholar. He is famous in lexicography for laying the foundational principles that led to the creation of the Oxford English Dictionary. there can be, Richard Trench said, there can be more meaning hidden in the history of the etymology of a word than in the history of an entire military campaign. Am I a Mason? No, I'm not a Mason. So 2 times in the Constitution, they got the word commerce. They say Article 1, Section 8, that Congress, the legislator, has power to regulate commerce. They don't create it. It was not created with them. It was given to them. Them, right? To regulate commerce with foreign nations, states, and Indian tribes. They said no. And this is what? This is Article 1, Section 9, that no preference shall be given by any regulation of commerce or revenue. All right. So then we go to the states. Let me read some. Let me keep that there, actually. Let's go to state sovereignty. What powers do a minister have in court? Only the powers that you give it. This is what we're going to go over. State sovereignty. The Supreme Court of Georgia said that the states are sovereigns separate from the federal government. They said that in 2025, I think. 2018. The Supreme Court of Georgia, one of the original 13, said that the states are sovereigns, yes, separate from the federal government. Right? So we don't read the federal Constitution like it's talking to us or that it's about us. Why? Because we're not federal. I'm not federal. You might be a Fed. A lot of y'all in this comment section is talking real federal right now. Right? But they said that Georgia was sovereign. Georgia said everybody, all the states were sovereigns and that they were separate from the federal government. Ooh, I forgot about this. The Supreme Court of Virginia said the sovereigns were the people in Virginia. Who's the sovereign of Virginia? The people. Is the state government sovereign? It can't be. The Supreme Court of Virginia said the people are the state. Uh-oh, what did Georgia just say? Now, don't forget, Georgia's one of the original 13. Virginia is obviously one of the original 13. Georgia said the states are sovereigns, separate from the federal government. Then Virginia said the people are the state. So who are the sovereigns separate from the federal government? They said when the 13 original states acquired their independence. Did they say the federal government was? Never mind. Let me stop. When the 13 original states acquired their independence, each acquired the powers, prerogatives, and rights of the British Crown, but also all the powers and rights held by the people collectively in their capacity as sovereign. They said, the Supreme Court of Virginia said they acquired full and complete sovereignty. Full and complete? Full and complete sovereignty. Let me read some more stuff. And then somebody remind me to go to Alabama. Alabama's going to teach us something very fantastic. Hawaii. Here we go. I like Hawaii. We like Hawaii. The Supreme Court of Hawaii said the states and their courts, the states have their courts and the territories have their courts. Yeah, we're not Australian, bro. I'm sorry. We don't do creditor and beneficiary stuff here. We're talking about sovereignty. We're not talking about commerce. Yeah, all those words relate to commerce. There's only one type of court in America that can hear issues of commerce, and that's an admiralty court. So we're not talking about that. That's not how sovereigns work. The states have their courts and the territories have their courts. They said the state, this is the Supreme Court of Hawaii, the state being an independent sovereignty within its sphere. What states are y'all from? Kentucky being an independent sovereignty within its sphere. Alabama being an independent sovereignty within its sphere. Ohio being an independent sovereignty within its sphere. Massachusetts being an independent sovereignty within its sphere. Arizona being an independent sovereignty within its sphere. California being an independent sovereignty within its sphere makes its own constitution and laws. But we just told you who made our courts. We made our courts. And we establish who the Supreme Courts are in America. We just told you, an injured party. See, we don't know the definition of the word court. I have my book. I have it. Where is my book? It may be. I have it somewhere. But I have it on the computer. What is a court? Nope. A court is not a bank. Not in America, it's not. Understanding the courts. Let's search understanding. That's one version. Yeah, actually, this might be it. What is a court, everybody? This is my book. A court is the place where the sovereign sojourns with his regal retinue. What's a court? A court is the place where the sovereign sojourns with his regal retinue. Here's another. A court is the king's palace, the place where justice is to be judicially administered. What is a court? The person and suit of the sovereignty, of the sovereign. The person and suit of a sovereign. In America, who starts a lawful case? The injured party. Right? We just read it. Supreme Court of Hawaii said the states have their courts and the territories have their courts. They said the state, being an independent sovereignty within its sphere, makes its own constitution and laws and creates its own courts and fixes its jurisdiction. What's the jurisdiction of a court in Arkansas? They told you. The person in suit of the sovereign. Watch this. I actually have it on here. They said, who is this? This is the Supreme Court of Indiana. They said, there's a distinction between torts and crimes based upon the criminal offense. A crime is an offense against the sovereign, which means injury is pursued by the injured party. The real distinction between a tort and a crime is not in a difference between their tendencies. The discretion of the individual injured. How does a court case get created in the 50 states? See, we're not talking about everything in the world. We're not talking about Australia. We're talking about the 50 states. We're not talking about the federal government. We're talking about the 50 states, which I'm repeatedly proving are sovereign and independent. That is a huge bug. Killed it. So who's the sovereign? See, sovereignty is not a commercial term. See, banks, creditors, equity, all that's commercial. We didn't create that. That doesn't apply. We're not talking about that. We're talking about sovereignty. Where does sovereignty come from? God. God doesn't deal in commerce. See, commerce is all based on fictions. And there's only one type of court that can hear issues of commerce. They said the states have their courts. Massachusetts got a court. And the way you know if you're in a lawful court or not in a lawful court is if there is an injured party. If there is no injured party, then you know you're not in a lawful, you know you're not in a Massachusetts court. You know you're not in an Arkansas court. You know you're not in a Kansas court. You know you're not in an Oklahoma court. If there's, see, Oklahoma will teach you this. North Dakota will teach you this. I just got back from North Dakota. Okay, well, in North Dakota, what we think is North Dakota is not just North Dakota in that physical geographical boundary. You got like 5 different nations inside of North Dakota. You got, when I was there this winter. I can't even think of the names. They got this thing called the Badlands. Look up all the reserves in North Dakota. All right, so let's, I don't know the name of those people's tribes, but they got like 3 tribes that I know of in North Dakota. You got the 3 Native American tribes, you have North Dakota, and you have the feds. That's 5 different jurisdictions right there. Okay, well, if you get in an issue with one of those tribes, there's only one type of court that can hear that issue. And it's not North Dakota. North Dakota can't hear an issue of a foreign nation. North Dakota doesn't have international relationships, doesn't have international connections. If you want to deal with the Native American tribes, you have to go to this foreign jurisdiction called the United States. You can't represent a fiction. It's a fiction. It's not real. Yeah, it's time to block them. Everybody say bye-bye, Australia. That's how you know they sending feds in. That's when you tell the truth, they send the feds in. Yep, feds, right? So there's only one type of court that can hear issues. If you get in trouble with that nation, you can't go to North Dakota. The feds have to deal with the issue. I'm sure, I don't know anything about Oklahoma, but Oklahoma's the same way. They got Native American tribes right there. They drive on the same roads, right? There's different, it's all a social construct. It's all fake, right? Okay, but North Dakota has a court. North Dakota has its own Supreme Court. It's got its own jurisdiction. It fixes its own jurisdiction. The same way the Native American tribe, I don't know nothing about them, but they probably fix their own jurisdictions and on their own land and on their own reserves, right? And then the feds got their little piece. And then you go to Oklahoma, it's going to be the same thing. They got their own tribes. They got their own things. And they got their own courts. And then the feds got their piece. And then Oklahoma has its piece. Same with Georgia. The same with, wherever else. Right? So they said the state is an independent sovereignty within its sphere. I forgot what I was reading. But so I was just reading stuff, right? So they said, while a territory being a political dependency under the absolute control and dominion of Congress, its organic law is made by Congress and its courts. Who makes federal courts? A territory is a political dependency under the absolute control and dominion of Congress. Okay, well, Arizona's not under the absolute control and dominion of Congress. And the people of our Arizona are not supposed to be, under the absolute control and dominion of Congress. They said Congress's organic law is made by Congress. This is Hawaii talking. Hawaii said, we got a law. Hawaii has a law. Hawaii has a constitution. They said, when you go on a federal territory, if you go onto a military base in Hawaii, that's a federal territory. When you step off of the military base in Hawaii, you're in Hawaii. Hawaii is in charge of Hawaii. Right? I say this all the time. You go into a post office. Tennessee don't have a post office. There may be a post office in Tennessee, but Tennessee don't have no post office. Every time you go into a post office, you are leaving Tennessee and you are going into the United States. You're going into the District of Columbia. You're going into a territory. Every time you go into a Social Security administration office, you are no longer in North Carolina. You are going into the District of Columbia. You're going into a federal territory. Yeah, that's all I got for that one. Who is this? This is great. This is great. This is great. This is great. This is the feds. They said the legislator is bound by the Constitution of the state. This is the feds talking about the states. They're talking about Massachusetts. They said the legislator is bound by the Constitution of the state. They said the legislator of Massachusetts is in no just sense sovereign. They want you to believe they're sovereign. They want you to believe they can write whatever they want and it's magical law and you have to obey it because the government is in charge of you. They said the legislator of Massachusetts is but an agent with limited authority. It cannot rightfully transcend the bounds fixed in the Massachusetts Constitution. Look, they said in England, Parliament is omnipotent, which is true. I talk about this. I got these videos on YouTube where I explain the Declaration of Independence. And that when you study King George I and King George II, well, they weren't English. They were German nationals. They were the King of England by blood, but they were not born in England. They were not nationals of England. And as a result, they did not care about England. And because they did not care about England, they didn't even speak English. King George II didn't speak English until he was like 40 years old. Right? So they said, who is this? This is the New York Supreme Court said in England, Parliament is omnipotent. Why? How did they get that? I thought the King of England would have been omnipotent. No. In the period of King George I and King George II, they gave legislative sovereignty over to Parliament because they were never there. And these people called Jesuits, which is a topic in and of itself, infiltrated Parliament and started writing statutes and laws over all of the territories of Great Britain, which would include the 13 colonies, right? And that's really the beginning of the beef of the Revolutionary War. King George I was German, did not speak English his entire life. King George II was German. He moved to England later in life. He learned English later in life. And both of those guys gave legislative sovereignty over to Parliament. Who is Parliament? Parliament is like Congress. They write statutes, codes, regulations, ordinances, whatever, yada, yada. Okay, well, in England, they're sovereign. They get to do whatever they want, and whatever they say is the law there. That was literally the reason for the Declaration of Independence. They don't tell you this. King George III is the king over Great Britain during the period of the Revolution. Well, guess what? King George III is half German. He's literally the son of a German. He happened to be born in England because King George II moved to England later in life. So he is half German because of his father, and English, I believe English by birth. I don't actually know that, but I'm pretty sure. But he is the king of England, being in England. And he is half German. So they said in Parliament, the legislator gets to do whatever it wants in Great Britain. That's them. They said here, so let me read it right. They said in England, Parliament is omnipotent. That means all powerful. That means they get to write whatever they want and call it law. They cannot do that here. They said that principle does not prevail with us. They said here, the sovereign and absolute power is in the people. I'm going to read some more stuff. Let's see here. California said in all domestic concerns, each state of the union is deemed to be an independent sovereignty. In all domestic concerns, each state of the union is deemed an independent sovereignty. Say independent sovereignty. Say your state, whatever your state is, say Pennsylvania is an independent sovereignty. They said, as such, it is its province and its duty to forbid interference by another state, as well as by any foreign power. You're like, what's this got to do with jurisdiction? Everything. This is the United States Supreme Court. It said it will doubtless be urged that within the sphere of their jurisdiction, the states are as independent of the federal government as the state government within its sphere is independent, or I'm sorry. The states are independent of the federal government as the federal government within its sphere independent of the states. They said one of the reserved powers was that to establish a judicial department. They said all of the 13 states were in the possession of this power and had exercised it at the adoption of the federal constitution. They said that constitution is not talking to us. They said the 13 states had 13 constitutions. You hear these feds on the internet, oh, really? There's 2 constitutions. No, really, there was 14 constitutions. And they said that as a result of the 13 states, they were independent of, this is the United States Supreme Court telling you this, after the Civil War. They said the states are independent of the federal government. They said all of the 13 states were in possession of this power and have been and exercised it at the adoption of the Constitution. And they say it is not pretended that any grant of that power is found in that instrument. They said they're not talking to you. You have a constitution. Kentucky got a constitution. It's had it forever. They said the states are separate and distinct sovereignties, and they act separately and independently of each other. This is the United States Supreme Court. Jurisdiction. I'm trying to see one more thing. I think New York is going to teach us something. Let's go to New York and then we'll explain jurisdiction. I want to kill a presumption that people magically end up in court. That's when I read these books that these people be talking about and they don't know what they're talking about. People do not magically end up in court. You end up in court somehow, some way. Where was I going? Actually, I need to go to Alabama. Nobody told me about Alabama. Alabama, then New York. Alabama, then New York. Alabama. Let's exit all that. And then New York. See, New York will teach you something. New York's got some of the nastiest cases you've ever seen. Constitutional law. Let's do Alabama. Let me do Alabama. I never find it. Actually, I never find this case when I need to. We may not go to Alabama because I keep forgetting to add it to Alabama. It's on here. Let me search real quick. If not, we'll just go to New York. New York's got enough for everybody. Let's search commerce. All right, let's go to New York. But Alabama has a case where Alabama's government is trying to make a claim before the United States Supreme Court about its sovereignty. They're like, no. Oh, the Alabama's sovereign. And the Supreme Court said, yes, you are sovereign, except for when you're in a commercial contract. When you're in a commercial contract, you reduce your sovereignty. And you are obligated under the laws of commerce to fulfill the obligations of that contract, if it be valid. In that case, it was a valid contract. All right, New York. Actually, I really need to find that case. That was like the whole premise. Let me see. Jurisdiction. Yep. Well, no, that's not it. Jurisdiction, jurisdiction, jurisdiction. Let's see. Minimum contacts. Yada, yada, yada. Are y'all learning something? Let me see if I can find it. All right, let me see if I can find this case. It's Alabama versus some like railroad company or something. When dealing with cases, how can states move to the federal? Well, the federal, y'all keep giving the feds jurisdiction that they never should have. See, the issue I'm trying to prove to you guys is how a case gets created. And that's the most difficult conversation. That's why I need this case to help me. I don't need help with the case, but I need y'all to get it. How does a case get created? Because we keep saying cases, cases, cases. We don't understand how you end up in court at all. I'm not gonna find it. As soon as I end the live, I'll be like, oh, there it is. Oh well. So, jurisdiction. How does a case get started? Is that it? Is it in the Patreon? Did you get that from the Patreon? No. Okay. I'm trying to find it on the Patreon. But that might be the case. Let me see. Oh, let's see. Okay. Oh, it's not that much. Let me see. Yeah, it doesn't talk about sovereignty. But there may be this website. Let's see. Well, let me see commerce. Immunity. No, this might not be the case. Maybe that might be it. Let's see. I don't know. I can't find it right now, but that's okay. But the principles are still the same. You can't claim. Well, that's not what I'm talking about. All right. So how does a case get created? A case gets created two ways. We already talked about one way. An injured party. Right? We talked about it. That's the one the state constitution creates. It establishes. And that is the Supreme Court. That is the law of the land. That is of the common law. What is the court? A court is the person in suit of the sovereign. So, you got a legit case if there's an injured party who went to the government and said, somebody damaged my life or took something from me, damaged something of mine, or put their hands on me in some way or in some form, right? There was a breach of the peace in some way. And then they would have a grand jury, or it would go right to the magistrate, and the magistrate would give it to the jury, the petite jury, right? All of these presumptions that I see on the internet say, oh, you magically end up in court and now you have to fight jurisdiction. That's not how that works. That's not how jurisdiction is conferred at all. The question is always, if there is no injured party to identify you, or there was no eyewitness to identify you, how does the government know who you are? That's the question. Or if it's in relation to your property, how does the government know who your property is? What did New York say? Constitutions and statutes should be construed with reference to the doctrines of the common law. The constitutional and statutory provisions provide that a person shall not be deprived of life, liberty, or property without due process of law. Excuse me. Let me go to my book. I keep forgetting I have the answers. No, the lawyer is not how they know who you are. California's government said the acceptance or retention of a state ID shall constitute the consent that a service of summons may be made upon him. What's a service of summons? What's a summons? How does the court know who you are without an eyewitness and without an injured party? That's why I was going to read state sovereignty. Let me go to Florida real quick. Who is it? Florida. Where's the Florida Supreme Court? Where's Florida? Where's Florida? Florida, 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 Florida. Florida. Oregon, Florida. Boom, Florida. Florida said, I read this the other day, the states of the Union still possessing attributes of sovereignty shall be immune from lawsuits. Now, we read it. Hawaii said it, and what state said it? They said the people are sovereign. Virginia. Let's go back to Virginia. Virginia said it. The people are the sovereigns. The government has no power. Oregon told us the government has no power it gets to exercise unless it was bestowed from the Oregonian to the Oregon government. Virginia. Who is the sovereign of Virginia? I couldn't find that case online. I forgot about that. Yeah, this is a nasty case. Yeah, they have it redacted. You can find the case online, but they got it redacted. They got, redacted mean they got big black bars over the stuff they want you to see or they don't want you to see. Yeah, this case say all of this. So I found the case. They said the sovereign are the people. They said, and the people are the state. They said in the same case. They say when the original 13 states acquired their independence, each acquired the powers, prerogatives, and rights of the British Crown. They said the people of Virginia became as equal as the King of England. They said that after the Civil War. They said the original 13 states acquired their independence. They said the people are the state. And then when the original 13 states acquired their independence, each acquired the powers, prerogatives, and rights of the British crowns, but also the powers and rights held by the people collectively in their capacity as sovereign. And they said they acquired full and complete sovereignty. They said the people of Virginia got whoever the king of Britain is today, Virginia is that. The people of Virginia is that. New York. I always read this. The Supreme Court of New York said the people of this state as successors of its former sovereign. Who was the former sovereign of New York? The King of England, King George III. They said the people of this state are entitled to all the rights which formerly belonged to the king by his prerogative. How many rights? All of them. It's not even the one they said. They got one where they say the people are the kings. New York, nasty, y'all. I got some nasty New York cases. New Yorkers are the kings of New York. Here we go. That's the one I was looking for. Yeah, the other case ain't nothing. Here we go. They said, okay. Oh, I love this stuff. The federal constitution says that the people of each state are to be, each state is to be guaranteed a Republican form of government, right? What's a Republican form of government? A Republican form of government is a government in which the sovereignty is vested in the people directly, right? They said, this is the Supreme Court of New York. They said the people in their sovereign capacity. They said we usually just say the people are sovereign and are the source of all political power. I got a case, you go to Pennsylvania. Pennsylvania say they got this thing called, they define what the word commonwealth means. They said the word commonwealth means the sovereignty of the people. They said before we called it a commonwealth, we called it res publica. Okay, well, that's the same phrase that's in the federal constitution. They said in New York, they say the same thing. They just say the people of New York. And they said the people in their sovereign capacity. They say we usually say the people are sovereign. They say all this political power is the sovereign power which they possess. This is the Supreme Court of New York. Then here's another case. They said we are met with the question on whether the statute under which this proceeding was instituted has any application. Seems to have a well-established principle of the common law, that the crown was not bound by a statute. What do you mean the crown? So they're saying at common law, remember, they're talking about way back in the day. The crown was not bound by a statute. unless his name was in it. They said this law, called a statute, is presumed to be made for subjects only. This is the same case. They said, okay, so they say this is New York, right? Then they say in the same case, this thing called the United States courts also hold that the sovereign power is not bound by general words in a statute. Same case, same case. They said when we examine the decisions of our own state, this is New York talking about looking at New York cases. They said when we examine the decisions of our own state upon the subject, we find that the English common law rule is that the king is not bound by a statute. By the adoption of the Constitution made the law of this state, and that the state was not included in the general expressions of a statute. They cite another New York case inside of this New York case. They said in this case, the English rule was again followed. They say in a New York Supreme Court case, the English rule, what? They said the common law was again followed. And it was held that the state was not bound by an insolvent or bankrupt law unless the name was in it. They said the people are not bound by an act of this kind unless they are named in it. They said the king is not bound. They said the people of New York are the king. They said the people have succeeded to the rights of the king and are not therefore bound by general words in a statute when any right or interest might be divested by or taken under it. Are the people of New York bound by a statute? No. So you get to Florida and they say the states of the Union still possessing attributes of sovereignty shall be immune from lawsuits without their consent. The states of the Union, this is the Florida Supreme Court, the states of the Union still possessing attributes of sovereignty shall be immune from lawsuits without their consent. They said Florida, in the same case, they said Florida is immune to lawsuits and that Congress has no authority to subject a state to the jurisdiction of a federal court. I mean, it don't get no simpler than that. They say it again. In another case, Florida has retained the status of a sovereign. Florida was admitted into the Union on equal footing with the original states in all respects whatsoever. They said Florida was admitted just like the original 13 states, sovereign. Then they said in the year 2000, we should keep in mind that sovereignty is in the people of Florida. They said in another case, sovereignty is in the people of Florida. They say in another case, the Bill of Rights became a part of the federal Constitution on December 15th, 1791. But it had already been made a part of fundamental law in Virginia on June 12th, 1776. And they said it was embedded in other state or colonial constitutions. They said this thing called the Bill of Rights has its grassroots in the Magna Carta on June 15th, 1215. They said its declared purpose was to guarantee the personal and political liberty of Englishmen. And they said this philosophy of the divine right of kings is that sovereignty is in the people. They said this is attached to all state constitutions. So should you be paying attention to the federal constitution? No. The federal constitution is not talking to you. They say it again. Supreme Court of Florida said, we heartily reiterate the view that sovereignty is in the people of Florida. They say it again. Under our form of constitutional government, sovereignty is in the people of Florida. Okay. They said Florida's immune to lawsuits and you cannot be brought into the courts of your own making without your consent, right? How do you consent? Let me search the word summons again. California said the acceptance or retention of a driver's license or a state ID shall constitute the consent that service of summons may be made upon him. How do you end up in court? We're going to talk about two things. We're going to talk about how you end up in court, and we're going to talk about how your stuff ends up in court. Right? How do you end up in court? The state ID. Why? Because you had to show up to the... People don't like to admit this. Like, we never went to I never heard of a DMV. Yeah, we all went to the DMV and got state IDs. Yep, sure did. Because we believed, ignorantly deceived, that we were required, that the government gets to tell people what they can and can't do, and that we were required to obey the government without questioning it. I mean, most people don't even know they have a state constitution. So we know they didn't question it. We know they didn't question the government when they got a state ID. Me too, right? So how do you end up in court? Because people believe you magically end up in there, and they want you to believe that they magically have power to make you go to court. But the question is always, how did they know who you were? Right? How did they know who we were? This is fundamental. You want to know law? It starts with jurisdiction. This is the most important subject. How did our stuff or ourself end up in court? It's not magic. How did they know our name? Either you gave it to the officer or you gave it to somebody else another time. How did they know where you live? People know it subconsciously. They watch police chases online and they say, oh, he got away. The police officer canceled. They were told to cancel. They said everybody who watches the video like, oh, they'll meet him at the house. They know where he live. How? How do they know where he live? That dude got a driver's license. That dude got a state ID. You cannot get a state ID without giving an address. You gave it. We gave it. I gave it. You gave it. We gave it. They know exactly where we live, right? Okay, well, how does your stuff get towed or get seized? Well, some stuff we think is ours and it's not, but some stuff is ours and they get it anyway, right? So that bank account, that's not your bank account. Remember, there's only one type of court that can hear issues related to banking. Right? They got this thing called a citation. Let me see what I can read. All right. So yeah, the acceptance or retention of a state ID, the acceptance or retention of of your car essentially being in their system. How did your car get in their system? How did you obtain a car? Right? It's all the same. So we got state IDs and cars, right? State IDs and cars. That's one way you end up in court over those issues, right? Well, state ID, you can end up in there over any issue related to a person, right? That's a fiction. Let me see what else. All right, so then they got this thing called a citation. What's a citation? That's what the police officer hands you, right? He say, what's the first thing he asks you for? License and registration, baby. We need that. Need that. See, we've overlooked all of that. So I'm only making this so you're aware when other people are lying to you, or when other people are uninformed, or people may be trying to deceive you. They'll say, oh, well, you just end up in court. And once you're in court, no. How did you end up in there? How did they know who you were? Did you talk to somebody? Did you give somebody your information? If we want to use the federal constitution, you can't fight that one either. Because they say you got the right to not to be compelled to be a witness against yourself, not to be compelled against self-incrimination. Okay, well, did you incriminate yourself? Because if there was no injured party and there was no eyewitness, how did they know who you were? How did they know whose name to put on the citation? They can't create a ticket without your name. Where'd they get your name from? Where'd they get your address from? Right? Now, this is an easier said than done situation, so don't, oh, well, how do we get out of it? Yeah, I'm still on that journey just like you still on that journey, right? But they got this thing called the citation, right? We read it. The acceptance or retention of a state ID shall constitute the consent that service of summons may be made upon him, right? All right, bet. Then they say, in order to summon you, in order for a service of summons to be made, a citation must be given. Excuse me. They say a citation, the definition of a citation is a summons to appear. A citation is a summons. A citation is not evidence. They just want you to be up in there. That's just how they get you in there. They say, yeah, we'll talk about the merits of the case later. But how'd you get up in there? Because people say, oh, well, they don't have jurisdiction. We can't say that. They may not have had lawful authority to create the case. But jurisdiction is just how you get up in there. It's just the power of the courts. Who gave the courts its power? We did. So you think, oh, I'm going to explain it to the police officer. The police officer don't want to hear what you say. Why? You showed up on his computer. He said, oh, Jeffrey, look at Jeffrey. And then he got a list of options for Jeffrey, right? Jeffrey on the computer. Jeffrey talking about I'm sovereign, you ain't got no jurisdiction. Actually, you're on the computer, bro. And I got 3 options. I can bust your windows out. I can drag you out the car and beat you like a Rodney King case. Or you can hand me that license and registrations, proof of insurance, right? That's the options he got. He don't have no, oh, well, he don't have jurisdiction. That ain't on the computer. That's not on there. Right? They said you can't even end up in there unless you've accepted or retained a state ID. That's what California said. California said that is consent. That service of summons may be made upon him. You understand how important this is? That's why they shrunk the audience from 40 people watching this down to 10. They said, how do you end up in court? Service of summons. How do you get a service of summons? Over your person? Okay, well, you have to accept or retain a state ID. That's just how it works. You have to accept or retain it. So you might got one in your back pocket right now. Okay, well, that's how you end up in there. What they do, in order to get a driver's license, you got to take 2 tests. You got to take the computer test. You got to take the driving test. You got to fill out an application, I think. You got to put your address down. I think they want a social security number and a birth certificate, proof of address. They want 2 bills. They want you to take a photograph. They want you to, you want to vote? Go ahead and vote. You're a Republican, a Democrat. What are you? Yeah, it don't matter. You pick one. Yeah. And then give us $100 and we will mail you a state ID. All right. Well, that constitutes the consent. That service of summons may be made upon the person. What's a person? I say this all the time. The Apostle Paul says in Romans, like chapter 7 or 8, that he says, the thing I don't want to do, I do. The thing I don't want to do, he said, the thing I want to do, I don't do. The thing I don't want to do, I do. O wretched man that I am, who will deliver me from this body of death? They said a citations is a summons to appear into a spiritual court. It's a summons. That's the definition of a citation. When a cop hands you a ticket and say, you can pay this right now and be called guilty, or you can go try to fight it in court where we already got it rigged. So don't worry about that. Okay, well, that's a citation. That's not evidence of a crime. They said a citation is a summons. This isn't a law dictionary. This is the law. They said this is a summons to appear into a spiritual court. All right, we just spent half the day talking about that Arkansas got a court. They don't have no spiritual courts. We got the separation of church and state. We don't have no spiritual court. So if you ended up in there where there was no injured party and no eyewitness, there's only one way you can end up in there. You had to be summoned to appear in a spiritual court. They said ecclesiastical courts proceed according to the course of the civil and canon law. They didn't say according to the course of the common law of England. They don't do that. There's no such thing as a citation at the common law. And they call that the law of God. They said there was no such thing as a citation at common law, and the common law is defined as the law of nature and the laws of God. How can he serve you and be a witness against you? He can do it because the acceptance or retention of a state ID constitutes the consent that serve, and summons can be made upon you. Do you have a state ID in your back pocket right now? And don't say it's suspended or it's expired. Those are state IDs still. There's a difference between an expired state ID and no state ID. There's a difference between what they call it, revoked. Yeah, there's a difference between an active state ID, a suspended state ID, an expired state ID, and a revoked state ID. Okay, those are still state IDs. Those are still state IDs. There's a difference between state IDs and no state IDs. Does that make sense? What's the best identification? What for what? There's no such thing as identification in law. They said the acceptance or retention of a state ID shall constitute the consent that a service of summons may be made upon him. The California court said the voluntary acceptance of a benefit is consent to all obligations arising from it, or ought to be known, because y'all love to tell me, oh, well, they didn't give me full disclosure. Yeah, you ought to have known that when you went and got a state ID. To the person accepting, they say you were supposed to do your homework before you went up in that place. So yeah, they said a citation. How do they create citations? You have to have a summon. What's a citation? A citation is a summons to appear into a spiritual court. They said it's a witchcraft term. They said we don't have none of that in America. They said the ecclesiastical courts proceed according to the course of civil and canon law by citation. They said a citation is the act by which a person is summoned. They said this is also the name of the process used in English ecclesiastical, probate, or divorce courts to call a defendant to respond before them. That's all witchcraft. I'm actually about to prove it to you. Actually, I'm not. Maybe I'm not. I forgot. Yeah, here we go. They said, they said this citation thing, summoning a person into court where there's no injured party, is a pretense of an official right to do an act made by one who had no such right. They said this citation thing is an act wrongfully done by an officer. Sounds right to me. Under the pretended authority of his office. And this is grounded upon corruption. They said this is defined as an act wrongfully done by an officer. I already read that. They said this is an act wrongfully done to imply an illegal claim of authority. They said when they hand out citations, this is an act that is evilly done by an officer, and it is grounded upon corruption. Remember I told y'all earlier about King George I, King George II? Okay, well, they said it. I got it. They said these people called the Jesuits, born in the, where is this? This is in my book. Where is what? This is in my book called Understanding the Courts, or the Discernment of the Vigil. They said these people called the Jesuits, that's a homework assignment. Go find out who they are, where they came from. The Jesuits, born in the King's Dominion, so they may have been born in Great Britain. Hold on, I got a text message. Oh, I messed up the whole. Got to clean the lens, right? They said this is done by a pretended act of Rome. That's how you clean your lens, everybody. You got to clean it. Got to keep it clean. There we go. Right? They said these people called the Jesuits. Is it on your Patreon? It might be. Go to the court section of the Patreon. Go to the courts, what they call collection of the Patreon. The Jesuits born in the King's Dominion. So they would have been born in England. But they were ordained by the pretended jurisdiction of Rome. And they said they did things under the pretended acts of Parliament. Uh-oh. Didn't we just talk about Parliament? The Supreme Court of New York said in England, Parliament is omnipotent. They do whatever they want. They said not here. They said this was in the early 1700s. This is the same time of King George I, King George II. The Declaration of Independence says that King George has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, and that King George has given his assent to their acts of pretended legislation. Who was giving out pretended legislation? They said this thing called the citation comes from the ecclesiastical courts. We don't have none of those here. They said when they give out a citation, they said this is an appearance to distinguish something from that which is real. That's not real. That citation ain't evidence of a crime. Don't they call it? Google a crime. Google the definition of a crime. They're going to say, oh, well, a crime is a violation of a criminal statute. Okay, well, a statute can't be violated. But it appears to be true. They wrote it down, didn't they? They say, well, we write laws, and that's the law. You got to obey the law. Don't think you're above and better than laws. We're a nation of laws, not of men. But men wrote those laws. They did not come from the law of God or the law of nature. They said this is an appearance distinguished from that which is real. They said this is a deceptive appearance. I was going to look up one more thing. Let me see. Boom. Here we go. Yep. To pretend. Those who falsely pretend an extraordinary commission from heaven terrify and abuse the people with false denunciations of judgments. Oh, this is fun. They said people who do this, hand out citations. They said they falsely pretend an extraordinary commission from heaven. They terrify and abuse the people with false denunciation of judgment. That's what we're living under right now. That I bet you there's probably almost no real court cases almost no real court cases in existence, except for the ones where the government is the criminal. But you probably can't say that stuff on the internet. But they said all persons who pretend use any kind of witchcraft, sorcery, enchantment, or conjure. This is from a law dictionary, y'all. They say they pretend from their skills in the occult sciences. An imposter, one who pretends to be someone else to deceive others to receive the benefits of a negotiable instrument. Don't you hear these feds on the internet talking about, oh, you gotta claim the name, you gotta get your negotiable instruments. Okay, yeah, those are feds. They said there's only two types of jurisdiction outside of an injured party and a eyewitness. They said they got this thing called in rem and in personam. What is in rem? In rem is against the thing. The Supreme Court of the United States said that admiralty acts only in rem. How do you know if you're in an admiralty court? If they're acting in rem, go to your state code and search the phrase in rem. We proved it, didn't we? Didn't Arizona? We proved it. Arizona said every taxation is in rem. They said, oh, yep, here we go. This is Arizona. Arizona said a statutory procedure to foreclose a tax lien is in rem against the property and not in personam against the individual. They said the Arizona statutory procedure to foreclose a tax lien is in rem. Okay, well, Arizona don't have no in rem powers. And what they say, in Admiralty acts only in rem. I'm going to read the whole sentence. Admiralty acts only in rem and no person can be subject to that jurisdiction. Uh-oh. What jurisdiction? We talking about jurisdiction the whole night. The whole day. It's the middle of the day. Can be subject to that jurisdiction, but by his consent on a contract. Well, there you go. How you end up in there? How we end up in court? In rem. YouTube, I can't see none of them comments. I don't know what y'all saying. Say in rem. In rem. They said Admiralty acts only in rem. Okay, I started this earlier. I said there's only one type of court that can hear issues of commerce, right? You go to the federal constitution and they say Article 1 says they got commerce in there twice. They got in Article 8, Congress shall have the power to regulate commerce and that no preference shall be given by any regulation of commerce. Okay, well, you get to Article 3 of the Constitution and they don't mention commerce. What do they mention? They mention admiralty and maritime jurisdiction. I'm trying to clean my lens. Look at that, that's so cool. There we go. They said there's only one type of court that can hear issues of commerce. What kind of court is that? Admiralty acts only in rem, y'all. Only in rem. And no person can be subject to that jurisdiction but by his consent on a contract. What they say? Let me see. I got one more. No, that's it. So we go back to summons. They said the acceptance or retention of a driver's license shall constitute the consent that service of summons may be made upon him. How do we end up in court? In rem. Your state ID is in rem. Your car, when they have information on your car and your property, it's in rem. Your bank account is in rem. Your property, I forgot about that because I don't have no property. But if you got a mortgage or a house and you've ever filled out a government document concerning that piece of paper or concerning that property, quote unquote, okay, well, that's in rem to them. How did they know what your property was or how? They got it through a means of a fictitious contract. What else? Divorce is in rem. How is divorce in rem? The marriage certificate. Child support, child custody is in rem. How is it in rem? Y'all love talking about it. Go ahead and say it. The birth certificate, right? So you understand all these things subject us to the jurisdiction of the courts. And because we've been deceived for years, we have to learn the law as we're exiting the process, as we're exiting the system, right? So These people on the internet gonna tell you, all you got to do is fill out more pieces of paper. Until I met those Amish people, I believed them. The Amish people don't fill out nobody paper. They don't be in nobody car either. They don't be in their own car. What is jurisdiction? Jurisdiction is the power of the courts to hear and decide a case. That's it. The operative word is a case. How does a case get created? For your person, the acceptance or retention of a state ID. So how do you end up in jail, so to speak? How do you end up in handcuffs? I don't like that word. How do you end up in handcuffs? State ID. How does your stuff end up arrested? See, technically that state ID is in REM. I don't know if I already said that. Right? Okay, but your stuff, your car primarily, if you got it from a dealership or somebody got that car, that used car from a dealership, then that dealership gave that information to the DMV. Point blank period. There's no other way to get it. And then bank accounts. Those Amish people don't have no bank accounts. They know better. They didn't have no bank accounts at the beginning of the country. Right? See, we're getting ready to celebrate. Well, they are getting ready to celebrate 250 years of the United States. Like, they care. They don't give two craps about this country. And how are they going to celebrate it? They're going to celebrate it with commerce. They're going to have a wrestling match. They're going to have all these sales and deals. And okay, well, all of those are commercial maritime terms. And they're going to say they're going to celebrate freedom and independence. Okay, well, none of those things bring freedom or independence. They're going to have a wrestling match. They're going to have 50% off of hot dogs and foolishness, right? None of that is the law. All of that is foreign, right? So it's all a big deception. The Amish record their births in the... Do the Amish record their births in the Bible? How do they record? Now, we got different types of Amish, but I'm primarily talking about the devout Amish. To my limited understanding, they don't record them at all. Now, you got some that are more liberal. They get on airplanes, they drive, they do whatever. But I'm assuming you can record it in the Bible, but you wouldn't need to record it for anybody else to see it. Sure, you could probably record it to keep the record in the family. That's fine. I'm nobody, but that would be logical. But to record it for somebody else outside of the family to acknowledge, you wouldn't need to do that. Yeah, just genealogy. If you want to know who was around during this time period, you got the family Bible, sure. But to give it to somebody else to acknowledge your existence, that's not a thing outside of commerce. And then there was one more thing I was going to say. The Amish people that I met and asked, they said they did not have birth certificates. They told me to my face they did not have birth certificates. And it was something else I asked. Social security cards. They don't have social security cards or birth certificates, which I don't think you can get one without the other. But yep. So the answer is not recording, which obviously is incredibly hard. But that's why community is important. That's how the Amish do everything. Y'all need to go look up those Mennonites. We don't like the Mennonites like that. They give a great example. Those Mennonites it's like 5,000 of them. They all just migrated to some like area in Mexico, and they're getting in trouble with the Mexican government. It's pretty hilarious. But they're unified. They got community. They can set up an entire civilization in months. We don't have that at all. So the last thing I was going to say is I was talking earlier about the Apostle Paul said, the thing I want to do, I don't do. The thing I don't want to do, I do. O wretched man that I am, who will deliver me from this body of death? I think that was Romans chapter 7 or 8. And in Roman times, so ancient Rome, when you were guilty of a notorious crime, they would chain you up to another person, to another man, right? Okay, well, when that man had to use the bathroom, guess what you had to do? You got to go to the bathroom. When it's time to eat, guess what you're going to do? You're going to eat. When it's time to go to sleep, you're going to sleep. Okay, well, when that dude passed away, they would say, oh, wretched man that I am, who will deliver me from this body of death? Why? Because that dude literally had a deceased corpse next to him. They were both guilty of a heinous crime, right? Okay, well, that's a picture of the word person in law. They say you look up this word called person, they say it's a fiction, but that fiction person is treated like a corporation. Okay. They said the acceptance or retention of a state ID or a driver's license shall constitute the consent that service of summons may be made upon him. They said a citation that they issue, they don't issue it to nobody but a dead person. And they get that dead person to summon or to appear inside of a spiritual court. Well, who summons things in the world of witchcraft? A magistrate. A magistrate or a magician. I stumbled upon this the other day. In Africa, they are talking about this. They say the judge is a witch. They say the judge is a wizard. They say it. They said, no, we don't know about these courts thing. These people in the robes, it's something with them. They talking about it. They all over the internet talking about it. They say the judge is a magician. They practice witchcraft in the courts. Uh-oh. Okay, they say when you get a citation when they give you a citation, they say that's a summons to appear in a spiritual court. It's a law dictionary. He said only ecclesiastical courts proceed according to the course of civil and canon laws. See, we don't understand this either. In Africa, they got common law countries, common law of England countries, nations that were under the jurisdiction of Great Britain at one point, and they had access to the common law of England. And some of those African countries know the common law of England. And they know when something is contrary to the common law of England. They said, no, some of these magistrates out here practicing witchcraft, they are magicians. They are magi. They said, in this definition of the word citation, they say every archbishop may cite any person dwelling in any bishop's diocese within his province for heresy. Okay, well, that's all the Roman Catholic Church. That's all they do. They only issue citations to bodies of death, to corporations. All right, that's it for the day. I know how to shrink a crowd, huh? All right, we'll try it again next time. See ya.